Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
Yeah. May please, Your Lordship, we filed the report yesterday.
Nothing.
Sorry.
A status report has been filed by the state through its joint secretary in the Public Works (R&B) department on July 10, 2023. Paragraph. As has been noticed in previous orders, the Shillong to Dauki Road under the JICA is Japan International Cooperation Agency. What is it, JICA?
Japan India Japan.
Under Japanese funding, how does it go?
After having noticed in the previous awesome format, the children of people all the questions.
Funding is divided into 5 packages. Full stop. Paragraph. This petition filed in public interest pertains to the felling of trees in Shillong as part of package number 1 of the entire project. Full stop. According to the status report, the technical evaluation of bids is under process, and the work for the first package has not yet been allotted after the previous contractor abandoned the project. Paragraph. Even if the contractor were to be appointed, it is evident that the Indian Institute of Geomagnetism is unwilling to part with any land, and the National Highways Infrastructure Development Corporation Limited is of the opinion that it is not possible to change the alignment at this stage to avoid any land being taken from the observatory of the Indian Institute of Geomagnetism. Full stop. Thus, comma, in effect, comma, even if the contractor were to be appointed, comma, till the IIG relents, comma, package 1 cannot be, now work under package 1 cannot be undertaken seriously. Full stop. As far as the other packages are concerned, there are myriad problems with the landowners. And though some work in the undisputed areas had been carried on, comma, it does not appear that any of the packages is ready for work being taken up or the requisite work being delivered. Paragraph. In such view of the matter, comma, the further felling of trees for the purpose of package 1 should not be carried out till such time that the work under package 1 is awarded to a contractor and the contractor is able to take up the construction unimpeded, comma, including near the observatory of the Indian Institute of Geomagnetism. Full stop. The matter will appear 4 weeks hence for further report to be filed.
Item number 2.
May it please your lordship.
Yes.
My lord, they have filed a supplementary affidavit, my lord. So, my lord, we will require 1 week's time, my lord, to file a reply to that supplementary affidavit, my lord.
Lordship, if I may only point out, much of the contempt petition is of an order of 14th December.
Yes,
Lordship had laid down
applicant has
and
filed
all the
applicant has filed a supplementary affidavit. The respondents seek
1 week.
some time to deal with the same. Paragraph rejoinder to the supplementary affidavit will be filed within a week from date. The matter will appear a fortnight hence.
Item number 3.
Wait, please, your lordship.
Ready? This is a teacher matter,
Yes,
that
Lord.
qualification.
Yes, sir.
You take it up right in the end.
Item number 4.
Yes.
My lord, the department is on appeal against the order by the state, my lord. My lord, the issue involved is the respondent succeeded in the proceeding before the tribunal, my lord. And ultimately, we were required to refund the tax amount paid by them, my lord. So the question now, my lord, is whether they are entitled to any interest on that, my lord, and for which period, my lord.
And
For which period? Here what happened, my lord, if I may just point out a few facts, my lord. Around 2012, my lord, the investigation was started on the apprehension that the respondent has evaded certain payment of duties, my lord. So when the investigation was going on, my lord, they volunteered to deposit the disputed amount, my lord, that was around 94 lakh rupees under protest, my lord. Subsequently, so-called notice was issued to them. The first order, my lord, the order in original confirmed the demand. They filed an appeal before the tribunal, my lord. The tribunal came to a conclusion that for certain amount they were liable to pay, my lord, and certain amount so 70 lakh something, the tribunal held that they are not liable to pay, my lord, and about 20 lakh rupees, 70 80 lakh rupees they are liable to pay. So there was a direction by the tribunal to refund that amount, which was paid by them under protest, my lord, that point of time. Now the tribunal order came, my lord, in the year 2020, my lord. The deposit was made by them in the year 2012, my lord. Now, after that order was passed, my lord, the department calculated the amount of refund and refunded the amount, my lord, to them. Then they filed an application for payment of interest on that refunded amount, my lord. The original order, my lord, and the appellate order were against them, my lord. The adjudicating authority came to conclusion that they are not entitled to interest. The appellate authority gave some relief to them, my lord, and accordingly we paid interest for because the issue here, my lord, the adjudication order of sestate, the final order of sestate came in the year 2020, my lord. Now the Central Excise Act requires, my lord, that from the date of order, if there is delay beyond 3 months, my lord, then the department is liable to pay interest also on that. Now in the second round of litigation, my lord, the learned sestate is directed to pay the interest on the entire amount from the year 2012 till the date of payment, and that also at the rate of 12% per annum, my lord.
What is the bank rate?
My lord, here the Central Excise Act provides for a notified rate of interest by the government, my lord, and at the relevant point of time that was 6%, my lord. My lord, rate of interest is one aspect, my lord. The second aspect, my lord, is entitlement of interest, my lord, at all, if at all, my lord. If I may just point out the two provisions of Central Excise Act, my lord. Section 11B, my lord. 11 capital B.
Yes,
So, my lord, I was pointing out section 11, capital B, my lord.
yes, you read 11B.
So, my lord, here, my lord, in explanation, my lord, towards the end of the section, my lord, explanation capital B, my lord, it defines a relevant date. And then clause small ec, my lord, in the same section it says, in case where the duty becomes refundable as a consequence of judgment, decree, order or direction of appellate authority, appellate tribunal or any court, the date of such judgment, decree, order or directions.
This is export.
Lordship, this is Senmet credit. When the investigation happened, they alleged that certain Senmet credit was not eligible. So under protest, we made the payment. We participated in the adjudication proceedings. We got a stay from the Honorable Sestet because the maximum amount of the demand was paid. When the order was finally heard by the Honorable Sestet, on the merits, to the extent of 99 lakhs the demand was, out of that 78 lakh was dropped. We had paid 94 lakhs when the investigation happened in 2011, Lordship. So, post the Sestet order, we applied for refund, citing it is not a duty at all, because it was paid under protest. And Lordship, it's a settled jurisprudence that unless it is a payment of tax or duty, then 11B comes into picture. It was a revenue deposit, Lordship. So, in case of revenue deposit, we requested for the refund of 78 lakhs with applicable interest. Because Lordship, neither 35F, which is a clause for pre-deposit, would come into picture, neither 11B, because 11B speaks about only duty. Then Lordship, the refund order came to be passed without any interest. There was no mention about why interest is not to be paid. We went against that refund order, we went before the first appellate authority. The Commissioner Appeals referred to section 35FF, which is the interest for pre-deposit, and stated because the amount was appropriated by the tribunal, as pre-deposit during the stay hearing, therefore it should be treated as a pre-deposit. And therefore under 35FF, I was allowed an interest of 35,000.
35FF is pre-deposit for appeal.
Lordship. The learned Commissioner Appeal stated because you had the learned tribunal in the first instance had stated no further pre-deposit is required because you have already paid 94 lakhs. So it deems that it is to be treated as pre-deposit. So he passed an order on the ground that it is a pre-deposit, and under 35FF you are entitled to refund.
35FF
has no application, Lordship, with due respect, Lordship. Next, Lordship, against that we went to the Honorable Tribunal. Honorable Tribunal, Lordship, has followed the jurisprudence. Recently, Lordship, the principal bench of the tribunal in 2021 was considering the same issue in Parle Agro, and after taking into account all the provisions, all the notification under 11B, 35F and also 11D, the Honorable Tribunal was of the view that because it's a revenue deposit, in case of revenue deposit, the excise law does not prescribe any particular rate of interest. It prescribes from 5% to 30%. And Lordship, having reference to the judgment of Honorable Supreme Court in Sandvik Asia, which was under interest under income tax under section 243, when the Supreme Court stated in such situation the rate of interest should be 12%. So the Honorable Tribunal followed that and ordered an interest of 12% on the rate. Coming to the point, Lordship, as to from when I am eligible to take that, 35F is not applicable in my case, Lordship, because it is a precondition for appeal. 11B will not be applicable for me, Lordship, because it is not a duty at all. So in all such cases, Honorable Madras High Court, Honorable Delhi High Court has over a period held, in all such cases where the amount was paid under protest during investigation, the period of refund will lie from the date of deposit till the date of refund. Lordship, about certain compilation which the Lordship says, I would produce it.
Yes. Stands to reason, Dr. Mudhikar.
Lordship, after that, the Honorable Sestet,
Because 11B
My lord.
is refund of duty. Duty, interest, duty and interest.
My lord.
Lordship,
Now, if they are not claiming refund of duty or interest,
Lordship.
you made a demand on them. Whatever good, bad, you may have made a demand for 1 crore, they said in their wisdom, they deposited a certain sum of money pursuant to your demand. Your demand was for short payment earlier,
My lord.
and they make a deposit so that interest does not run, penal provisions don't apply, penalty interest don't happen.
My lord.
But they did it under protest
My lord, only one.
without admitting that such amount was due.
My lord, there is only one aspect, my lord. The allegation was they have unduly availed the Senvet credit, my lord. So they reversed the Senvet credit. My lord. There was no actual payment of amount in that, my lord.
Reversing Senvet credit is the same as giving money, it's cash.
My lord. So now, my lord, what happens? Because ultimately the tribunal decided their entitlement, my lord. Holding that they are not entitled to.
What the net effect is, as on the date of your demand, 70 lakh was not additional Senvet credit which was taken by them. That's the final order.
My lord.
Order fined 70 lakh.
They are not liable, my lord.
So therefore, they had put in deposit a sum which was not refund of duty or interest, which figure has been ascertained to be 70 lakh. Now that is a money that you enjoyed or continue to enjoy from the period that the Senvet credit was reversed, which is deposited,
My lord.
till the time that you refund. In the usual course of business, unless you return it with interest, then they're losing out, because that interest is compensation. Interest is also, in economics, to compensate you with some money for the loss of the buying power of the money that had originally been paid. Say with 70 lakhs, when they deposited in 2011 or 2013, they could have bought, let us say, 4 cars. The 12% that you're paying now is in lieu of 70 plus 12, entitling them to buy the same basket of goods now. And whatever 11B prohibits is interest on refund. Since this does not amount to refund, it stands to reason.
My lord, they file an application for refund, my lord, after Sestet's order.
Which one?
After Sestet passed the order, my lord, they file an proper application for refund.
Whatever. They have to ask for refund of their deposit, not refund of duty. They've asked for refund of deposit, not refund of duty. Because that adjudication is over.
But the principal sum was already paid, my lord.
Principal sum has been refunded to them.
Lordship.
They'll be entitled to interest from the date of the deposit under protest till the date of refund. And if the income tax analogy applies, which we look into,
My lord.
then they'll be liable to get that. No one can unjustly enrich himself, nor you the department, nor he the SSC.
My lord, what I understand, my lord, in the taxing statute, my lord, the mechanism is provided how the money is to be refunded.
Yes, provided it is additional duty. But its adjudication is complete and it's found that that is not the extent to which that they had underpaid. To the extent that they are underpaid, that adjudication, whatever is their liability, is complete. You hold money in excess of what they are liable to pay you to the extent of 70 lakh. For the period you've held this money,
My lord.
you're liable to refund it to them by compensating them on account of interest. This interest has nexus with inflation, nothing else. This interest is not a penalty.
Compensatory interest.
This is compensatory for to ensure that that amount gets them the same basket of goods and services at a later date. Otherwise, it would amount to unjust enrichment on your part.
Because, my lord, the Section 11 only provides that in case of deposit under protest, my lord, the limitation period of 1 year, because otherwise they are required to file an application within 1 year for refund of the money, my lord.
Which is of additional duty or whatever. This is not duty. This is consequent upon your issuing a notice, finding them to have short paid. They put in an amount.
To avoid interest and penalty.
They put in an amount which is equal to or less than your demand.
My lord.
If they had put in a money which was more than, or then they wouldn't have got for more than.
Correct. Yes.
Because that they're doing, unnecessarily, absurdly.
Correct, Lordship.
But if the deposit is less than equal to the quantum of demand, which is followed by an adjudication where the quantum is quantified, amount of short payment is quantified, then for the balance, whenever you refund it, between date of deposit and date of refund, interest, and whether it's 12% or whether it's 6% or whether it's 8%, that is of course we have to go by. And the analogy I think in income tax will work.
Well, my friend has given a compilation today, my lord. If I can.
Lordship, I'll just.
Yeah, there's nothing in the matter.
Lordship, and after
Nothing in the matter.
after the sestate order granting against my appeal for interest, that was passed on 11/4/2022. Then the department, we again go to them. Now we have a sestate order, you kindly give us the interest for the differential period. They again filed a ROM, rectification of mistake before the sestate, Lordship. That was dismissed on 28/10/22.
We are not concerned with
Lordship,
that.
so the actual refund arose, Lordship, in 2020.
Whenever they will actually pay till that date, and then
Lordship, till the day I have received my principal.
pay interest on interest. Even that we are going to. If you delay payment of interest, then what you are doing is you are taking away a part of the interest which is due to them. For the unpaid interest, we'll provide for
One
the
day's time,
date.
I'll just go through this and I'll have proper instruction on this one.
But these are all judgments of Lordship which were placed before the tribunal. I have nothing new, I have not added any single judgment which is new. It was before the Honorable Bench, tribunal in 2020 and then in interest matter also. Lordship, would request, your Lordship has taken into account. Rate, Lordship, I'll just show two judgments, which then I'll leave upon your Lordships.
And give him some time.
You can appear online also.
No, that is also fine. When?
After 2 or 3 days or maybe next week sometime.
Very well. The matter pertains to the interest awarded by the Central Excise and Sales Tax Appellate Tribunal.
Service tax, Lordship.
Oh,
Syntax and service tax.
and Service Tax Appellate Tribunal. Full stop. The department is in appeal, claiming that in terms of section 11 capital B of the Central Excise Act 1944, no refund is, no interest is payable for refund of duty or interest. Paragraph. In this case, the department raised a claim. When was it, Dr. Muzika? When did you raise the claim?
So cause notice, my lord.
Original claim, when did you say? Short payment.
So cause notice was 4/3/12, my lord. And the original order in original was on 15/10/2012, my lord. October 15th.
What did I say?
In this case,
The department issues a show cause notice in 2012 claiming that additional SENVAT credit had been availed by the respondent SSE, full stop. An order in original followed in December 2012, in October 2012, finding the SSE liable to refund a sum in excess of.
Lordship, order was confirmed, the demand was confirmed. We went to tribunal against that when we got the refund order.
No. When did you deposit? Upon
2011.
show cause notice.
Before show cause notice, during investigation.
Cut it out. The department sought to initiate an investigation on the ground that the respondent SSC had claimed excess SENVAT credit than it was entitled to, full stop. At such stage, and before even a show cause notice making a demand was issued, the SSC deposited a sum of rupees
94 lakhs approximately.
a sum of about rupees 94 lakh under protest, full stop. In fact, the deposit was made by reversing further SENVAT credit to such extent, full stop. Reversal of SENVAT credit due tantamounts to paying amount in cash, full stop. Following a subsequent show cause notice and an order in original that found the SSC liable to refund how much? Order in original?
Order confirmed the demand.
Order in liable to, what was the quantum of demand?
Lordship,
7,55,150.
Very. And the order in original finding that the SSC was liable to refund SENVAT credit claim to the extent of over rupees 97 lakh, full stop. The SSC challenged the order before the tribunal.
Tribunal Kolkata.
And the tribunal found that the demand for excess SENVAT was good for about rupees 28 lakh.
About 16 lakh rupees.
16 lakhs.
16 lakh rupees.
Good for about rupees 16 lakh, full stop. After adding the interest and penalty on the excess amount of SENVAT credit availed, the tribunal found that a sum of rupees of approximately rupees 78 lakh was liable to be refunded by the department to the SSC out of the deposit of about rupees 94 lakh made by the SSC, full stop. That order only contained interest and everything.
Lordship, that order says that as per law, consequential benefits as per law. So we, basis that order, we wrote to the department that we are entitled to refund with interest.
That again before the
assistant commissioner, my divisional office.
And then after
They passed an order in original again, allowing me the refund of 78 lakhs without any interest.
and against that you went again to the
I went to first Commissioner Appeals. Commissioner Appeals allowed me interest for 35 days. And then against that order, I went to tribunal again.
well, the department has no paragraph. The department has no grievance as to the quantum of refund as directed to be made by the tribunal, full stop. However, the SSC insisted that the SSC was entitled to interest on the additional sum of rupees 78 lakh that it had deposited prior to even the show cause notice being issued by the department. Full stop. Upon the department refusing to pay any interest, possibly, because the sestat order did not provide for any, the petitioner appealed to the jurisdictional commissioner and, finally, not the petitioner, the SSC. The SSC's appeal came to be filed before the sestat, where the SSC maintained that the refund that the SSC was found to be entitled was not on account of any duty or interest on duty, but refund of a deposit that the SSC had made, and as such, the bar of interest in section 11B of the Act would not apply. Paragraph. It appears that several judgments were relied upon in such connection before the sestat, as the order impugned dated so and so indicates. Full stop. Upon the tribunal being satisfied that the refund in this case was not of any duty or interest on duty, the tribunal held that the SSC was entitled to interest from the date of the deposit till the date of refund, full stop. As to the quantum of interest, the tribunal relied on a Supreme Court judgment passed in an income tax matter to arrive at the figure of 12% per annum. Full stop. Paragraph. The department did not relent and did not immediately pay the interest in terms of the order passed by the appellate tribunal. Full stop. The department applied for, in effect, review of the order or correction thereof. Full stop. Such application has been rejected. Full stop. As a consequence, as it stands today, the department has not only not paid the interest at the rate of 12% as directed for the period that the department remained overpaid to the extent of the original amount of rupees 78 lakh, there has also been a delay in the payment of the interest that has been found due. Full stop. In commercial matters, such aspect has to be taken into account. Full stop. Paragraph. The SSC submits that the order impugned does not call for any interference, since it's reasoned and is justified on the ground that the refund what was directed to be made by the appellate tribunal in its original order was not refund of any duty or interest on duty, but refund of an amount that had been deposited in protest by the SSC upon the SSC perceiving that a claim was about to be made, and if the claim or any part thereof was found to be good, the SSC would be liable for interest and penalty to the extent of the shortfall or excess and VAT credit availed of. Full stop. Paragraph. Since the department seeks time to deal with the judgments cited judgments sought to be relied upon by the SSE, notwithstanding several of such judgments having already been referred to in the order impugned, let the matter stand over for 10 days. All right, so it'll be easier for us next time.
Lordship, can we have it on 26th if convenient to your Lordship?
What day of the week is it?
Wednesday, Lordship.
26th.
Grateful, dear Lordship.
Item number 5.
Yes.
May I please, Your Lordship? Your Lordship, this is the case, earlier Your Lordship was pleased to direct the medical board to examine the convict, Your Lordship, with regard to the insanity, that plea which was taken earlier at the time of trial.
What is the opinion?
Opinion they have given that he is recovering and he is responding to the medicine in MIMHAS. For last 3 years he is under treatment. So in my responsibility
At the time of trial,
yes.
was it found that whether he was fit to stand trial?
No, at the time of trial, the mother gave the prescription, then satisfying on the prescription, the court passed an order on 23/2019 to be examined by psychiatrists. But what happened, instead of examined by psychiatrists, a clinical sociologist has given the opinion. And court has taken view of that opinion without examining the psychiatrist, nor the clinical sociologist person was examined. So then trial goes on, and 313, he took the plea of his insanity, Your Lordship. He took the plea of insanity. So afterwards, when he is convicted, and it
Taking the plea of insanity is quite insane.
yes, 313 also he took the plea of insanity. So with that effect, Your Lordship, now latest decision 2023 of the Supreme Court, it says that is sufficient to prove that he can take the shelter of Section 84. Supreme Court say 2023, Your Lordship, the decision is 2023.
Look at it, come, tell us the substance before jumping to
Yes.
Supreme Court. We know what the Supreme Court does.
I know, I'm sorry.
We are not in awe of it.
Yes. So,
Please don't worry.
by a civil submission, Your Lordship, from the trial stage, the plea was taken.
Yes. If the trial court directed a psychiatric analysis to be made, by whom was it made? Was the person qualified to make the analysis?
This is Your Lordship. In fact, Your Lordship, this court also was pleased to direct the constitution of a...
Forget that. That is neither here nor there. The issue is whether the accused was fit to stand trial at the time of the trial.
Lordship, in fact, Your Lordship, yes, at the time of the trial.
Now, the trial court directed a psychiatric analysis or a psychiatric kind of opinion to be obtained. Now, who gave that opinion? Can that person be called a psychiatric or someone who can testify or give an opinion to the effect that he is fit to stand trial?
In fact, Your Lordship, at the time of the framing of charge, Your Lordship, the charge was framed on 14/2/2018. There was no plea taken that the appellant
There is a submission which has been made that the trial court directed the accused to be checked, medically examined. Is there such an order?
Your Lordship, that has been, yes, filed in the Miss case, Your Lordship, yes. If Lordship, there is a Miss case, that is the order dated 23/2019.
In the Miss case.
Lordship, yes, at page 7, Your Lordship. That is that.
Just a second.
Miss case 67. No?
This case will be with the petition.
No, Your Lordship, it's a separate Miss case, Your Lordship.
Page?
Lordship will kindly come to page 4.
You see what the purpose of the exercise is, that the whole purpose is that who are we trying to punish? We will punish a person who is guilty. But if a person is not in the mental condition to realize whatever he is doing is right or wrong, then the mens rea is absent.
But Lordship will kindly appreciate that at the time when he commits the offence, Your Lordship, he was not insane, Your Lordship.
Let us see. He has to be sane at the time of commission of the offence. He has to be sane at the time of standing to trial. He has to be sane at both stages. He may have been sane then and turned insane now. Again, he cannot stand trial. Where is the order?
Lordship, that is at page 4 of that miss
Page 4.
Lordship, yes.
Who did he murder? Any relative?
Yes, they are relatives.
A relative.
Yes.
Not sibling, father, brother, mother.
No, Your Lordship.
Yes, yes.
When was the offence committed?
Lordship, the offence took place on 16/9/2010.
2010.
Lordship, yes.
And he got bail in 2018.
Lordship, yes. And the charge under 302 was framed on 14/2/2018. And Lordship, he was arrested on 17, and on the same day he was taken for medical examination. If Lordship is pleased to come to page 5.
No, we'll come there later.
Lordship.
Come to page 4 that you were showing me.
Lordship, yes.
That Superintendent of Tura Jail is directed to send the accused to a psychiatrist at Tura Civil Hospital
Yes.
for checkup.
Yes, Your Lordship.
Now then, where is the
Lordship, kindly page 5, Your Lordship, the order dated 29/3/2019.
Very good. And then
Lordship,
where is the present report? Where is the present report?
Lordship, the present report, one is filed by Nikrim and one is filed by Memhan, Your Lordship.
Where do we get them? Are they part of the
Lordship,
record?
that has been filed by the appellant, Your Lordship, in a miss case number 67, Your Lordship. That is the medical report of 23rd February 2023.
Are they on record?
Lordship, yes. It has been filed by the appellant, Your Lordship, at page 7.
At page 7 of the same application?
Yes, Your Lordship. Of the, not in this application, Your Lordship, in the separate affidavit, Your Lordship. That report has been filed by the appellant by a separate affidavit.
Of 7th of March.
Just a minute, Your Lordship. Can you bear with me?
Pilgrims.
Yes, Your Lordship. Yes. Lordship will find that report at page 7 of that affidavit. Can you clarify? Copy done to.
Very well. This is report by Negrams.
by their board constituted under the direction passed by your lordship.
Now, is there anything from Mimans?
Then a lordship, from Mimham also we got one your lordship, that is on 21/3/2023, if lordship kindly.
Yes. Have they got a copy of this?
Lordship will. Lordship kindly come to the next page.
Yes, proceed on merits. Yes. You pursue this much more and we will enhance the sentence.
It's a live, your lordship.
You pursue it much more, we'll enhance the sentence. At every stage is found to be absolutely normal.
Lordship, it's a life imprisonment, your lordship.
Life till life.
Lordship, if kindly come to page 94 of
Is
the.
it life till life or not? We are asking a simple question.
What you say, to suffer rigorous imprisonment for life.
It's better since outside he misbehaves when he comes out. Better that he should remain in jail till death. Yes, tell us.
So, yes, maybe please, Lordship. Lordship, the evidence is PW1.
Where is the FIR?
FIR, your Lordship. At page 1, the type copy is at page 2, your Lordship.
FIR was filed 17/9.
2010.
Oh. Incident is of same date. Yes. What is your defense, Mr. Mantha?
My defense was, your Lordship, that what happened, actually the fact is, what from I gathered, your Lordship, that there was a quarrel of his brother and the mother with the deceased. And the victim, the convict, he came subsequently, your Lordship. When he came subsequently.
Victim or the convict?
Convict.
Convict came subsequently.
Subsequently, they were quarreling, the brother and the mother were quarreling. It's a neighbor. Then he came subsequently. Then they say that he stabbed the victim and the wife was in the veranda and saw, wife of the deceased.
So the FIR maker is the wife?
No, the father-in-law.
Father-in-law of the victim?
Victim. So, that's the case, your Lordship.
Yes.
Then if your lordship,
So according to you, what is wrong in the judgment and what is wrong, what are the grounds that you want to rely on?
my ground, your lordship, that mainly with regard to the insanity, your lordship.
Very good.
That,
Whatever you want to throw us on insanity,
Yes,
throw us.
so-
It's absolutely rubbish. Absolutely rubbish. And over here we'll enhance at least penalty or something. We don't want to be fooled around with.
If lordship has already decided, then I
Yes,
think
yes,
that's-
we've decided that. We'll indicate we've decided that. And we'll say that this is tomfoolery on the part of the appellant to take the plea of insanity. Everywhere he's been found to be sane. Perfect. We took it seriously. Yes.
So your lordship, that deposition of the PW1, there's the informant, your lordship. That's at page 34 of the paper book.
Yes.
Towards the bottom, your lordship,
The incident.
the incident took place around 6:30 p.m. while I was at home with my wife. Suddenly, the accused Taramia came to our residence, started quarreling with my son-in-law, Hasinur Rahman. The disease suddenly, at instant, the accused assaulted the disease with a knife, and the disease received serious injuries and shifted to Mankatsar Civil Hospital, where he breathed his last and died at Mankatsar Civil Hospital. Then the cross, your
So he
lordship.
was a witness.
Yes. He is the informant also.
But he claims to be a witness, eyewitness to it.
Yes.
Cross-examination?
Then thereafter, the cross, your lordship, this is State Defence Council, your lordship,
The,
cross. I remember the incident, next page, your lordship.
yes, the incident.
And it was at 8 years back. The incident happened outside the victim's home. It's a fact that I have seen the incident with my own eyes. At the place of incident, along with Taramia, his mother and his brother were also present. The incident happened around 6 to 6:30 p.m. It was not completely down, actually dark, actually.
Yes.
I have seen Taramia striking the victim with a knife. When I saw Taramia, the knife was in his hand, which he drawn out from his waist. So mother and brother presence is there, but mother and brother of this accused never examined, your lordship.
Never?
Never examined nor cited as a witness, your lordship. Then PW2, your lordship, that is on note in page 36. That's nothing has come forward. We can skip off, your lordship. I am not an eyewitness, he said. Then PW3, this is important, your lordship. See the wife of the deceased,
PW3,
PW3.
page 36.
Yeah,
Just a second.
third from the fourth line, important. I was sitting at veranda of my house. At that moment, the accused came and started quarrel with my husband. It Hasibur Islam. The quarrel was regarding land dispute at that moment. I saw the accused with a knife stabbing at my husband. My husband died on the spot, but after waiting for some time, we took the victim to Mankasa Community Health Center, but he was declared brought dead. The incident occurred at my husband's place in Thakuram Bari, then State Defence. The incident took place during the evening time. The incident happened outside the victim's place. At the time of incident, I was present along with the victim's elder brother and his mother. I saw Taramia stabbing my husband with knife. I saw the weapon in accused's hand. Those are direct evidence coming. Then next, PW4, Your Lordship, said that I received a summons so-and-so. I did not remember the date, month so-and-so. I have seen Taramia with knife assaulting.
Who is this? Who is PW4?
PW4 is sister-in-law of the deceased. Oh no, mother-in-law of the deceased.
Yes.
I have seen Taramia with knife assaulting Hasnul Islam. I have seen this at the place of occurrence. The murder took place outside my house, then cross, Your Lordship. Is the fact that I have seen the incident with my own eyes. During the occurrence of the incident, the victim's elder brother and his mother were present. I did not see the striking with a knife at victim by the accused, as I was inside the house, and when I heard the scream, I came out and saw the victim lying on the ground, and I saw the accused holding the knife in his hand. The accused was alone without any companion. Then 5 is the essay. The cross was declined. He just registering endorsement of the case. Then IU, Your Lordship, is PW6. That cross part, Your Lordship permit me to read. Actually, the disease when found at his bedroom in complainant house was not dead or not died at the time, and he was found. Yes.
Yes.
The crosspot, Your Lordship. Actually, the disease when
Died.
died at that time, and he was found injured. Hence, he was taken to the Mankachar CHC, where he was declared broad dead. So I sent the dead body to Tura Civil Hospital for postmortem examination, and I have conducted the inquest over the dead body at the morgue in Tura Civil Hospital. When I found the weapon, there was no blood stain on the dagger. I have not sent the seized weapon for FSL examination. I have taken the statement of the witnesses at the place of occurrence. The complainant and his daughter were the eyewitness in the instant case. I do not know what is there in the postmortem report, even though I do not know about the postmortem report, but since the disease had died, hence section 302 was charged. And PW7 is a doctor conducting the postmortem, Your Lordship. And the cross was declined.
Doctor. External injuries, stab wound in the back on the right, 1 centimeter away from midline, in the 8 intercostal space, abrasion on left hand,
Three injuries.
Yes. These are the witnesses.
Yes.
Where is your 313?
And the judgment also elaborately discuss about this.
Where is your 313? 313.
313.
330, Your Lordship. 30. 30, Your Lordship.
60.
No, 3, Your Lordship.
30.
30.
Your Lordship, yes.
Question number 2.
Let me see.
Lordship.
You see.
What do you have to say to this evidence, Your Lordship? I was blamed for the murder of my friend, but I did not do it.
Tutored to say unsound mind. Now I'm fine and I understand.
Only question 3 to the plea. Question 3 to the plea. Yes,
Yes. What is wrong with the judgment?
Judgment, it has discussed all those,
Where is the judgment, Mr. Mantha?
judgment is at page, Your Lordship, 85, Your Lordship.
85. Quite a short judgment. Now, you did not deduce any evidence as to his
No evidence.
mental capacity.
No. Only the things that in 2019, the mother gave the prescription and all of the psychiatrist, that's all.
Open and shut case, what do you say?
Your Lordship, in fact, as soon as I was appointed as a legal aid counsel, I've gone through the records. That time, I found that order dated 2019. Then I took the plea of the insanity, Your Lordship,
It's fine.
to assist
Medical
your.
psychologist has examined, that's the same thing. Yes. Life and 5,000. Yes.
So that's all, Your Lordship, since Lordship is not even. In fact, as a legal aid counsel, Your Lordship, I'm trying to find out that if.
You legal aid or appointed by, you cannot take the court by. Yes. This is quite an open and shut case, except that considerable time has been wasted on a wild goose chase that was eminently avoidable. Full stop. The distraction has to be dealt with before dealing with the merits of the matter. Full stop. Paragraph. It appears that in course of the trial, in the midst of the trial, the mother of the appellant herein without adducing any witness, produced some prescriptions claiming to have been issued by a psychiatrist who had treated the appellant. Full stop. However, the trial judge recorded in his order of March 20, 2019 that the accused in the dock did not show any sign of mental disorder as he interacted normally and without any sign of mental disturbance. Full stop. Paragraph. The judge also went on to record that the medical test report of the accused pertained to his liver functioning, and though a psychiatrist's prescription of September 2018 had been produced, the trial court deemed it expedient for a specialist to examine the appellant herein. After recording that the appellant's mother claimed that since the appellant's release on bail in 2018, the appellant seemed mentally disturbed and went roaming open quote, went roaming here and there, hence, he was not found at home, for which he was rearrested, full stop, close quote. Paragraph. Accordingly, by the order of March 20, 2019, the trial court directed the superintendent of Tura jail to send the accused to a psychiatrist at the Tura Civil Hospital for checkup and examination of the mental status of the accused and to submit a report in such regard by April 3, 2019. Full stop. Paragraph. The superintendent of the district jail Tura complied with the direction and had the appellant examined at Tura Civil Hospital. A report in such regard was filed, which was taken up by the court on March 29, 2019. Full stop. The order passed by the trial court on such date recorded exactly as follows, colon. Next line, open quote. Seen also the reason of referral filed by Srimati SMT Chuonti, Chuontie, Shira, Shira, clinical psychologist, Tura Civil Hospital, wherein, it is reported that the accused has no presence of cognitive impairment and mental illness. Full stop. Next paragraph, in the quotation itself. It is also reported that he has the ability to reason out and understand abstract concept, including morality, and that he has also ability to analyze the consequence of action, and lastly, it is also reported that he has low impulse control. Full stop. Seen also the administration of psychiatric evaluation. Full stop, close quote. Instead of the trial court, now where I said the trial court, in this one, say, the report was placed before the Chief Judicial Magistrate, Ampati. Full stop. Accordingly, the matter was directed to be put up before the Sessions Judge on April 3, 2019, as earlier directed by the Sessions Judge in the order of March 20, 2019. Full stop. Paragraph. On April 3, 2019, the trial court took notice of the medical report pertaining to the appellant herein as furnished by the clinical psychologist in Tura Civil Hospital, full stop. Upon recording the findings of the specialist, the trial court required the trial to proceed in right earnest, full stop. It is evident that the specialist at the Tura Civil Hospital had found nothing wrong with the appellant, and the trial court duly accepted such report. Paragraph. Following the evidence being recorded of the witnesses at the trial, the appellant herein was examined under section 313 of the Criminal Procedure Code 1973, full stop. The evidence of each of the witnesses was summarized and the key points brought out by the sessions, by the trial court for the appellant to comment thereon, full stop. It is interesting to notice the appellant's response to the questions put to him by the trial court, full stop. Paragraph. The trial court summarized the evidence of the FIR maker, who was the father-in-law of the victim, who claimed to have been an eyewitness to the incident, full stop. Upon the trial court seeking the appellant's response to the evidence adduced by PW1, the appellant claimed that at the time of the incident he was young and was apparently playing with the deceased, as the deceased was a friend of the appellant, full stop. He went on to add that he saw 5 persons quarreling, and they were his brother, mother, the complainant's wife, and the deceased, full stop. He claimed that the victim was his nephew, but even though he said he was present at the place of occurrence, he claimed that he was not aware as to who assaulted the victim or stabbed the victim. He denied that he had assaulted the victim and insisted that he had no quarrel with the victim, as the victim was his friend. Paragraph. Interestingly, however, there appears to be a change of tack on the part of the appellant in his response to the second question, such second question also pertained to the evidence of PW1 and the assertion by such witness that the appellant's mother and brother were also present at the place of occurrence. Full stop. The appellant responded to such question by asserting his innocence before claiming that the complainant dragged him to the police station, open quote, because that time I was of unsound mind while my mother and brother, that time I was of unsound mind, ... close quote. Full stop. In response to the subsequent questions, the appellant had little to say and did not attempt to suggest his innocence, as he had done in response to the first question, but maintained that he was mentally ill at the relevant point of time. Full stop. Finally, upon the trial court inquiring of the appellant whether he would call any witness, he clearly responded in the negative. Full stop. Paragraph. On a reading of the appellant's examination and his response to the questions put to him by the trial court after the witnesses had been examined, it does not appear that the responses were incoherent or unsound. Full stop. After the initial attempt by the appellant to plead innocence, the appellant resorted to plan B, that he was mentally unwell at the time of the incident. Full stop. However, the appellant admitted to have been present at the place of occurrence, and it is apparent that the appellant was a witness to the incident, and the appellant corroborated that at least the appellant's mother and brother, along with the wife of the victim and the parents of the victim, were there or thereabouts at the place of occurrence. Full stop. Paragraph. It is elementary that for a person to be proceeded against for the commission of a grievous offence as in the present case, comma, the court must be satisfied that he had committed the offence consciously and that he was fit to stand trial for the commission of such act. Full stop. Thus, comma, an accused has to be found both to have been in good mental capacity at the time of commission of the offence and sufficiently good mental state to be able to stand trial for his action. Full stop. Paragraph. No evidence was adduced on behalf of the appellant in support of the somewhat irregular suggestion by the appellant's mother at the beginning of the trial that the appellant was of unsound mind. Full stop. If the appellant was of unsound mind at the time of commission of the offence, comma, it had to be demonstrated. Full stop. No attempt in such regard was made on behalf of the appellant. Full stop. Following the trial court's direction to have the appellant clinically examined, comma, the appellant was found to be in good mental shape by the clinical psychologist attached to the Tura Civil Hospital. Paragraph. Quite needlessly, comma, much is sought to be made by legal aid counsel of the fact that the trial court had required a psychiatrist to examine the appellant, but it was a clinical psychologist who had conducted the examination. Full stop. No attempt, comma, however, comma, is made to indicate that a clinical psychologist cannot assess the mental condition or fitness of a person. Full stop. Indeed, it is a clinical psychologist who is the appropriate person to assess the mental condition of mental state or condition of a person. Full stop. In any event, the report furnished by the clinical psychologist indicated appropriate tests having been conducted and, comma, the trial court, comma, upon due satisfaction in such regard, comma, proceeded with the trial. Paragraph. Further, comma, and more importantly, comma, it is said that the judge's eyes and the judge's assessment are probably the best. And, comma, in such regard, comma, the trial court recorded that the accused in the dock showed no signs of mental imbalance or disorder and appeared to be perfectly well orientated and responsive. Full stop. Paragraph. At the initial stage of the present appeal, since a ground of mental instability or insanity of the convict was taken, this court deemed it appropriate to have the appellant examined. Full stop. The appellant has been examined both at MIMHANS, give the full form, and at NAGRIMS, give the full form. And the reports clearly indicate that the appellant is responsive, aware, conscious, and conscious. Full stop. The entire exercise, including the charade by the appellant in course of his examination under section 313 of the code, was a diversion to scuttle the proceedings and gain undue advantage by resorting to a needless trick. Full stop. Paragraph. There never was, nor is now, any merit in the assertion by or on behalf of the appellant as to his mental capacity. Full stop. No evidence was adduced as to the appellant's mental capacity at the time of the incident. Full stop. Both at the time of the trial and at the time of this appeal, the appellant's mental condition has been assessed by experts and the appellant was found fit to stand trial and in perfect mental state as of now. Full stop. As of now, at least for the purpose of the present proceedings. Full stop. Paragraph. As to the merits, there appears to be very little to assess or adjudicate. Full stop. The FIR was lodged on September 17, 2010 by the father-in-law of the victim at the Monabari police station in the West Garo Hills, claiming that in course of a quarrel involving several persons, the appellant became ferocious and stabbed the victim with a knife, which caused the death of the victim. Full stop. In course of his deposition in court, the father-in-law of the victim as PW1 asserted that the incident took place at around 6:30 p.m. when he was at home with his wife, when the appellant came to the witness's house, started a quarrel with the victim, and assaulted the victim with a knife. Full stop. In his cross-examination, the father-in-law of the victim reiterated that he had seen the incident, that he had witnessed the incident, and it happened in the presence of the mother and a brother of the appellant between 6 and 6:30 p.m. when it was not completely dark. For good measure, he repeated that he saw the appellant striking the victim with a knife which the appellant had drawn from his waist. Full stop. Paragraph. The wife of the victim was examined as PW3. She claimed that she was sitting in the veranda of the house when the appellant came and started a quarrel with her deceased husband. Full stop. According to the wife, the quarrel pertained to a land dispute. Full stop. The witness claimed that he saw the accused with the knife stabbing at the witness's husband. Full stop. In her cross-examination, she repeated that she was present when the incident took place just outside the victim's house. Full stop. She also claimed that the appellant's mother and a brother were present at the place of occurrence and repeated that she had seen the appellant actually stabbing her husband with a knife. So, paragraph. The mother of the victim was examined as PW4. She claimed that the incident took place right outside her house and she saw the appellant assaulting the victim with a knife. Full stop. However, in her cross-examination, after saying that the appellant's mother and an elder brother were also present at the place of occurrence, she claimed that she was inside the house when she heard a scream. She claimed that she came out and saw the victim lying on the ground and the appellant holding his knife in his hand. Paragraph. The investigating officer referred to a dagger measuring about 11.5 inches, which was the murder weapon. The relevant knife was exhibited in court. According to the investigating officer, the complainant and the complainant's daughter were the eyewitnesses to the incident. Full stop. Paragraph. The doctor who conducted the postmortem report, who conducted the postmortem study, was next examined as PW7, and he described the external injuries that would be consistent with a person trying to ward off a knife brandished by a right-handed person. Full stop. The medical examiner referred to the abdominal injuries received by the victim and was of the opinion that the victim died due to hemorrhage of the abdominal organs and the shock following the assault. Full stop. Such medical practitioner indicated that he had conducted the postmortem examination at 3:15 p.m. on September 18, 2010, and his opinion at the relevant point of time was that the victim had died of injuries inflicted on the victim, antemortem injuries inflicted on the victim, some 24 to 26 hours prior to the postmortem examination. Full stop. On the basis of the paragraph, evidence before the trial court, there was little discussion which was necessary. Full stop. The trial court reproduced the material parts of the deposition of the witnesses and found that there was nothing but to detract from the eyewitness accounts which corroborated eyewitness accounts and the corroboration of the injuries and the cause of death by the postmortem examination. Full stop. By the judgment and order impugned dated February 12, 2020, the trial court sentenced the appellant to life imprisonment upon appreciating that for an offence committed under section 302 of the Penal Code 1860, no lesser sentence than life imprisonment could be awarded, if the maximum sentence of death penalty was found to be inappropriate. Full stop. Indeed, the manner in which the trial was conducted and the reasons furnished in the judgment and order impugned are found to be satisfactory. Full stop. This was not one of the rarest of rare cases which would warrant capital punishment to be imposed. full stop. Paragraph, accordingly, comma, criminal appeal number so-and-so 16 of 2022 is dismissed by upholding the judgment of conviction of February 12, 2020 and finding that an appropriate punishment of rigorous imprisonment till life together with a fine of rupees 5,000 having been awarded, full stop. As indicated earlier, comma, the minor distraction of the appellant being of insane or being of unsound mind does not warrant much attention, particularly in the light of the expert opinion obtained recently, full stop. Appeal number so-and-so is dismissed. There will be no orders to costs. Let an authenticated copy of this judgment and order be immediately made available to the appellant free of cost. Yes.
Much obliged.
Second call, item number 3.
Your amendment brought about two things.
Yes, Lord.
One was that if you stand for an election for these, then you have to sever. The other one is of parliament and legislature or local body. The other one is of political parties.
Please,
So there are two aspects.
please.
As to political parties, we would say that your decision is arbitrary, but it's not without jurisdiction. But as to legislature, parliament, state legislature, parliament and other authorities, it's without jurisdiction. Because only, even in respect of disqualification for state legislature, the state legislature cannot do anything. Only the parliament can do it. All right?
Yes, sir.
So we will just divide it into two.
Yes, sir.
Say the second part
Please,
of political parties. Plus, political party is a nebulous concept.
Please,
If we take it to be in the technical sense, meaning an organization which is registered as a political party with the Election Commission of India, which is not indicated. There are sometimes various other forms of political parties. Pressure groups are political parties. For instance, unions of teachers, unions of students, unions of staff, sometimes attain that kind of a political thing, which you have loosely used over here.
Yes, sir.
Without specifying anything.
Yes, sir.
So we will find that to be arbitrary.
Yes, sir.
And as far as the rest, we will find to be without jurisdiction.
Yes, sir.
Yes. Now, yes, Mani, you accept.
No, Your Lordship, yes, I am trying to formulate my point, my Lord.
Yes.
The issue is, what is falling from Your Lordship is that the state has no jurisdiction to regulate or even lay down that teachers of government colleges or even aided colleges are not qualified or they cannot contest election as long as they are in service. Because
What we are saying is that you are far removed from the state.
Yes, Doctor.
We are saying that the executive
Yes, Doctor.
has no authority
Yes, Doctor.
to discover, invent or prescribe a ground of disqualification
Yes, Doctor.
that will prohibit a person from offering his candidature
Yes, Lordship.
in a state legislature, parliament,
Yes, sir.
or of any local body.
Yes, Lordship. This was the,
Executive is complete.
yes, Lordship.
Even the state legislature may not be competent.
Yes, Lordship.
As far as legislature and parliament is concerned, they may be in respect of local bodies.
Yes, Lordship. So what is falling from your Lordship is probably flowing from Article 326.
Yes.
Because
Not only 326, 172 and the corresponding 116 or whatever the corresponding.
yes, Your Lordship.
Both for parliament and for state.
Yes, Your Lordship.
You see, even for the state, that is 172 or something.
Yes, Lord.
173 million.
Yes, Your Lordship.
Qualification of membership of state legislature.
Yes, Your Lordship.
A, B, forget it.
Yes.
C,
Yes.
possess such other qualifications as may be prescribed in that behalf by or under any law made by parliament.
Yes, Your Lordship.
So therefore, both for parliament and for state legislature,
Yes, Your Lordship.
the state has no authority, only parliament has authority.
So qualification, if Your Lordship sees 173, a person shall not be qualified.
123.
173, same, the first 173 itself, my lord. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless and C possess such other qualification as may be prescribed. 173, Article 173, my lord, first part, a person shall not be qualified.
Article 123 is
No, sorry, 173, my lord, same article.
173.
Yes, 173, which your lordship has been reading. A person shall not be qualified to be chosen to fill a seat in the legislature of a state unless he possesses such other qualification as may be prescribed in that behalf by or under any law made by parliament. So C requires that if the parliament prescribes additional qualification, you know, then that power is vested with the parliament, you know.
Yes.
And 326, your lordship will, Article 326, my lord.
Yes.
The election to the House of the People and to the Legislative Assembly of every state shall be on the basis of adult suffrage. That is to say, every person who is a citizen of India and who is not less than 18 years of age on such date as may be fixed in that behalf by or under any law made by appropriate legislature and is not otherwise disqualified under this constitution or any law made by the appropriate legislature on the ground of non-residence, unsoundness of mind, crime or corrupt or illegal shall be entitled to be registered as voter in any such election, my lord.
This is a voter.
A voter. So this right, my lord, so far as taking away right of the teachers of aided college or government colleges are concerned, my lord, we are not taking away the
Taking right of voter.
right to
You are
voter.
taking a right of candidature.
Right of candidate. My lord, so this right has to come from the constitutional scheme, whether they have this right under the constitutional scheme or under the statutory scheme, which the state cannot take away, my lord.
Yes. So let us take 173.
Yes, Lord.
And the corresponding provision is that for Parliament,
That is at section 84.
Section 84. So a person is in the negative.
Yes, Lord.
A person shall not be qualified to be chosen. Qualified to be chosen. Which means he can't even offer his candidature.
Yes, Lord.
Unless he,
Yes, Lord.
if you read it the other way,
Yes.
if he possesses these, then he is entitled to, a constitutional right is given to him to offer his candidature.
Yes, Lord.
And it is because the Article 84 and 173
Yes, sir.
begin with the negative that C is in the positive. If you read it otherwise, it would imply that unless the Parliament provides a ground for disqualification, every Indian citizen, every person
Yes, sir.
qualifying under A and B
Yes, sir.
is entitled to offer his or her candidature to be a member of the Legislative Assembly or member of Parliament.
Clear. This very aspect, my lord, I am grateful, your lordship, this Justice Joseph judgment. This very aspect, what is the nature of right under Article 326, not in the context of Article 173. That few paragraphs, 4-5 paragraphs.
Yes, it's given you the reference.
Yes, your lordship.
Not only that, it is there before in Justice Chilameshwar's judgment.
Yes, that very judgment, because Justice Chalameswar held that it is a constitutional right, and this constitutional right cannot be taken away by the state legislature unless, so that there the constitutional bench has disagreed with the finding or the views taken by Justice Chalameswar in Rajbala Milord. May I place that part?
Yes. That's why we give you all of this.
Yes, sir. That is, if, Hey, Lordship, I have prepared the compilation.
326 uses the word appropriate legislature.
Have you given him one?
Yes, sir. Lordship.
Give him one, we'll read the compilation and come and take it up some other time.
Yes, sir. And, my lord, there was one more judgment after we prepared the compilation, my lord.
That's a similar, you'll find over here, which is the, yeah. Yes. Now, you also must see another provision.
Yes, sir.
As my brother points out appropriately, 191.
Yes, sir.
191, does it have a corresponding in the pertaining to Parliament?
Yes, sir. Lordship.
Which article is that?
This article.
That will be 102.
102, my lord.
Again, you see in 102,
Yes, Lordship.
the last, if he is so disqualified by or under any law made by Parliament in
Yes,
both
sir.
cases.
Yes.
So it's not something, it has to be uniform.
Yes, Lordship.
It has to be done by the Parliament, not
Not by the state.
State of Nagaland can't have one rule, State of Meghalaya cannot have another
Yes,
rule.
Lordship.
It has to be something which is done only by Parliament.
Yes, Lordship. So, if I understand correctly, my lord, if the disqualification which we are adding by virtue of this amendment, my lord, this cannot be done by the executive order or even by state legislature. Because now I put a question to myself, my lord, because this disqualification is as long as you are part of the government service or you are part of aided college.
Over there, we have to see what is the rational basis.
No, so then,
Say, for instance, I hold a gun to your head and I tell you, make a confession. Will that be a valid confession?
no,
Now, over here, you're doing exactly that. You're saying, quit your job.
yes, sir.
Unless you quit your job, you can't do this.
Yes, Lordship.
In this day and age, when a job and that livelihood
Yes,
is
sir.
so important, if you attach a condition to a person's livelihood, then it's the same thing as putting a gun to his head
Yes, Lordship.
and making him confess.
So therefore, your lordship, two principles are being invoked in this case. One, that state legislature has no power, and second is that this condition is bad, this condition is because what I, in my humble submission, what we say is that you are free to contest, but since you are part of some establishment, we are imposing some regulation on you. Like for example, because it has got far-reaching repercussions also, because we impose similar conditions on government employees also.
On government employees also?
Oh, yes, my lord. So they can't also contest election, my lord, because we are attaching disqualification.
That's office of profit in any way.
So
they are government employees, office of profit, but we are not looking at the larger question.
Yes, sir.
We are only confining ourselves to this. It's not a, it's not a omnibus reference which has come to us.
Yes, sir.
We are dealing with a particular clause in an amending provision pertaining to a particular class of persons.
Please, sir.
But if this has repercussions, it has repercussions.
Yes, sir. That's one aspect which you.
Because that would be an office of profit. We will try and confine it to this.
Yes, sir.
But again, in respect of other government servants, office of profit will be the overwhelming.
Yes,
ground.
sir. Yes, sir. I understand that.
All the judgments are there. Both sides compilation is in over here.
Yes, sir. Both sides.
Both sides.
Both sides.
This will cover both.
Yes.
Very well. Tell us when.
Lordship, may give me some time to know this what has fallen from the Lordship is that
we've indicated to you.
Yes.
Plus there is one point we will not indicate to you, which is a very elementary point, and which is not noticed either in Justice Chalameshwar's judgment nor in Justice Joseph's judgment.
Other authority.
Whatever it is, that will come out in our judgment. It's even more basic than all this.
I'll try to.
Yes. No, we are telling you. What?
Yes. Lordship may have it after 10 days or 2.
Very well. Let the matter appear a further fortnight hence.
Hello, blessed.
Tomorrow give this file to me. Not today, but tomorrow. Oh, June, yes.
Yes.